It could be among the most significant abortion cases the Supreme Court has heard in decades, and now 6 justices, including 2 of whom Trump appointed and who originally voted against blocking Texas's restrictive new abortion law, are sending signals that they may be open to reversing a stance they took in September. After ruling not to block the sweeping Texas law, the Supreme Court is now hinting that it may allow Texas's abortion law to be challenged. The Texas Tribune wrote this: conservative justices Coney, Barrett, and Brett Kavanaugh seem to push back on Texas's unique enforcement mechanism. Their line of questioning and comments suggest they might side with the abortion providers in condemning the loophole that the law exploits to thwart judicial review. Much of the discussion today centered around how that enforcement mechanism could be replicated to cast a chilling effect on other rights protected by the Constitution, not just abortion rights, but also gun ownership, freedom of the press, and same-sex marriage. Here now, Justice Kavanaugh and how he laid out earlier today his position.
It could be free speech rights, it could be free exercise of religion rights, it could be Second Amendment rights. If this position is accepted here, the theory of the amicus brief is that it can be easily replicated in other states that disfavor other constitutional rights.
If Barrett and Kavanaugh side with the other justices who have already voted in favor of blocking the Texas law, it would be enough to move the case to lower federal courts for proceedings. It's not clear, however, if the law would be temporarily blocked in the interim. A decision could come within days, but next month the court will consider an even more consequential case, this one involving a Mississippi measure that could upend 50 years of precedent set by Roe v. Wade. Joining me now to discuss is the senior editor of Law and Policy at Rewire News Group and co-host of the podcast Boom, lawyer Imani Gandy, and executive director of the Afiya Center, Marsha Jones. So Imani, what do you make of the hearing today, the questioning back and forth with the justices and the lawyers over this Texas law?
I think the main takeaway is that it's a really difficult thing to go in front of the Supreme Court and argue that the Supreme Court doesn't matter, to argue that the Supreme Court in its role as interpreting the Constitution, that doesn't matter, because that's essentially what Texas is arguing. And that's what Kavanaugh and Barrett and Justice Roberts all pushed back against, because they seem to think that they don't have to follow the law. They seem to think that they can just go rogue, and the Supreme Court doesn't like that. But I do want to say that even if Coney, Barrett, and Kavanaugh and Roberts were to side with the providers, that is not a win. What that essentially does is it kicks the case back down to the lower courts. Whether or not the law will be blocked in the interim is still unclear. And as you said, in just 1 month, we're going to hear oral arguments in Dobbs versus Jackson Women's Health. And so to the extent that the conservatives on the court are uncomfortable with this enforcement mechanism, they're certainly not uncomfortable with the underlying fundamental issue, which is whether or not pre-viability abortion bans will remain unconstitutional.
Marsha, let's talk about kicking it back down to the lower courts. What do we know about the courts who would get this case if the Supreme Court pushed it back down? How have they viewed this issue of this law? Have they dealt with it already? And how are they leaning?
So if the Fifth Circuit Court get it, the Fifth Circuit Court have traditionally leaned very conservatively. As recent as a couple of weeks ago, when there seemed to be a temporary win with the injunction until it got to the Fifth Circuit Court. So if the Fifth Circuit Court get it, it could be just like this ping pong game that we find ourselves in. But more than likely, if the Fifth Circuit Court go along historical lines the way it has gone, because it's very conservative, they will uphold what Texas have put in place. It's very rare that
let's
they
get
don't.
back to that Mississippi case. Okay, Imani, let's get back to that Mississippi case that you were just bringing up. Why is that one even more pernicious than the case that they're talking about in Texas?
Well, that's the case that questions whether or not the state of Mississippi can ban abortions at 15 weeks. The rule for nearly 50 years has been that pre-viability abortion bans are not constitutional. A state is not permitted to interfere with a person's right to get an abortion up until the point of fetal viability, which is about 24 weeks. So that's still a good 9 weeks beyond what the state of Mississippi is trying to do. And so what we're starting to hear, the real pernicious issue that I'm finding with the Mississippi case, and particularly with the way the case is being discussed in the media, is that we're starting to hear more and more that a 15-week ban would be a compromise in some way, right? Like if we go back to what the founders would have wanted and we think about what abortion was like back then, in the 18th century, abortion was permissible up until quickening, which is about 15 weeks. That's about when you can feel the fetus moving. So there's going to be these arguments that we need to go back to that point. But, the fact remains, if the court allows Mississippi to ban abortion at 15 weeks, it will be a flat out reversal of Roe versus Wade. It would be a flat out reversal of Planned Parenthood versus Casey. It will not be any sort of compromise. And to the extent that there is any thought that anti-choicers, the so-called pro-life movement, is going to be mollified by a 15-week ban, I need to disabuse everyone of that notion, because what they are going to go for next is they're going to go for fetal personhood. They want fertilized eggs to have the same rights as breathing people. And I've quipped this on Twitter before. I've said before, there will be a point in time where fertilized eggs have more rights than Black women do in this country. And that's a real danger. So I really urge anyone watching this to not buy this line that a 15-week ban is a compromise. We cannot compromise on human rights, and we cannot let people make that argument.
Marsha, I was reading an opinion piece in the New York Times today about, that was kind of an extreme case, which is eventually, Roe is going to fall. That was their premise, that you have to start building in mechanisms that still allow women to have choices beyond Roe. What is your opinion about the long-term viability of Roe v. Wade to kind of stand this assault, which is, as Imani just said, is never going to stop. As long as Roe stands, the assault will never stop.
So I've always thought that Roe, as a stand, was not enough, and that there should have been we should have, from beginning, should have been fighting for mechanisms for access to abortions beyond what Roe gave, because Roe in and of itself was never enough. Like, Roe was never the ceiling, it was the floor. And so it didn't offer all folk opportunity for abortions anyway. So I do believe that they're not going to stop. There is no compromise. I was having this conversation this morning when I was doing my morning walk, and we were talking about that, and we was talking about the viability. And I was saying, look, folk are not going for viability or non-viability. Folk are going for personhood. People are going for life starts at conception. That is where the fight is going to go. So there have to be mechanisms in place. 15-week, even at 15-week, I know most of the women that come to our organization are at least 13 to 16-week gestation. And I can't say what of all the myriad of reasons that the Black women that we serve are late in gestation. I can guess on some things, but the 15, where Roe stand right now don't provide us with the necessary protections that we need, has never provided all of the necessary protections that we need. And so, now we need to be building for something greater, but this is a really late time to start building for something greater.
Imani Gandy and Marsha Jones, thank you both for joining me tonight. I really appreciate it.